Greetings. Welcome to Talk Law with Monare. I'm Hwaedi, your host. This is our second episode wherein we'll be discussing wills. September in South Africa is considered to be a wills month wherein legal practitioners across spheres will be providing pro bono services in terms of drafting a will. So, what might appear to be a simple question with an obvious answer is, what exactly is a will? Well, the answer is that a will is a specialized document which states how a person's estate must be and will be administered upon their death. So, in tonight's episode, we'll be looking at the requirements of a valid will. Then we'll move on to discuss which people can be disqualified from benefiting in a will, who is competent to write a will, and then lastly, we'll look at the controversial subject where we'll be discussing the aspect of beneficiaries and heirs in terms of customary law marriages. So, as we said, a will is a document. So, basically, what that means is that it must be drawn up. Now, with regards to the requirement, the first requirement for a valid will is that the will must be written by someone who is 16 years or older. So, a person who is competent to write a will is someone who is at the age of 16 years or older. So now, with that being said, however, if someone is suffering from mental incapacity, even though they may be 25, but they don't have the legal capacity to draft or to attest or to depose to a will. So first requirement is that someone must be 16 years or older for them to be able to write a will. The second one is that the will must be in writing. What this means is that it's either you can write it with your hand, you can type it in a computer, or you can print it out. But the will must be in writing. And the third requirement is that if your will is 1 page, then you must sign at the end of the will. If your will is 2 pages, then you must sign each page, So you can't write a will and then not sign it. If a will is unsigned, it's not going to qualify as a valid will. Of course, to every law there are exceptions. So one may make an application to verify the validity thereof, but it's not an easy process, So the will must be signed, and then the fourth requirement is that the will must be signed in the presence of 2 or more witnesses. So once you are done drafting your will, then you must request 2 or more people to act as your witnesses. So the minimum number of witnesses is 2, but there's no maximum. So you can have 6 people, you can have 3 people. So now, the next requirement is that those witnesses must sign the will in your presence and in the presence of each other. So what that means is that when you sign the will, your witnesses must be present and they must also sign. And when they sign the will, you must also be there. So basically, you can't send a will via registered mail or via email and say, hey, can you please sign this for me and send it back? No. Your 2 or whatever number of witnesses that you elect, they must sign the witness and they must sign the will in your presence and in the presence of each other. So you also can't go to witness A and sign and have them sign the will, and then you go to witness B and have them sign the will. All of the 3 of you must be in the presence of each other when you are signing the will. So what then happens if a person is unable, for one or other reason, is unable to sign their own will? Well, it's not a train smash. If a person cannot be able to sign their will, let's say for instance they're in hospital, their hands are no longer working, or for whatever reason they are unable to sign the will. So what they can do is they can sign the will with their thumbprint. Normally when you take fingerprints, you are using thumbs and index and all of that. So a person can sign their will with a thumbprint, or they can make a mark, be it a cross, be it a circle, whichever mark that they want to use to sign their will, they can do that. However, in addition to signing the will in the presence of two witnesses, the will must also be signed in the presence of a commissioner of oaths. So a commissioner of oath must be called, and the commissioner of oath will write a certificate to say, I hereby certify that I satisfied myself with the facts, with the contents of the will, and I'm satisfied that it is the wishes. These are the final wishes of the testator, the person who's signing, who's drafting the will. And then thereafter, the commissioner will also have to sign each and every single page. If it's a 5-page will, he'll have to sign all the 5 pages with you, whereas the witnesses are only required to sign the last page. So with regards to the commissioner of oaths, let's say, for instance, you sign the will either with your mark or with your thumbprint, and then immediately you die. Or rather, let's say you sign with a thumbprint or with a mark, and you die before the commissioner can attest to your will. So the commissioner is required to issue out the certificate to certify your will as soon as possible after you have signed. Even if you pass away 2 minutes before the commissioner can sign your will, the commissioner can still sign your will. It will still be valid, but it must be done as soon as possible. So now, from there we move on to the aspect of amending your will. How does one amend a will? There is a document called a codicil. So a codicil is a schedule or is an annexure to an existing will, which is aimed, or it's rather to supplement or to amend a will. So when you want to amend a will, you will now write a document which we call a codicil, which will serve as your subsequent will. So it's not a train smash. The fact that you've written a will, as long as you are still alive, you are allowed and well within your right to amend your will. So the same requirements for a valid will are the same requirements for validity in terms of a codicil. It must still be signed by yourself in the presence of two witnesses. However, the witnesses who sign a codicil need not be the same ones who signed your will. So you can have different witnesses when you are doing your subsequent wills. You are not bound to have the same people as witnesses. So another interesting factor when it comes to wills, especially when marriages end, people have a misconception that upon marriage, or rather upon the dissolution of a marriage, once the parties get divorced, some people assume that whatever else we agreed to during marriage, or whatever else we decided based on the marriage, has automatically changed by virtue of the marriage coming to an end. And one such assumption is regarding a will, because during your marriage, you might benefit your spouse in your will to say, when I pass away, I want company A to go to my wife, I want car A to go to my wife. But then you assume upon divorce that also changes your will. However, that is not the case. Even after you get divorced, you still have to change your will. You still have to make amendments to your will. So the law, because it understands that people might be going through depression, might be in distress, maybe not in their right minds after a divorce. The law provides that it provides for a 3 months grace period within which your will or the conditions thereof do not apply. So if you get divorced today, for the next 3 months, your will is not taken into consideration. Basically, your estate, if you die within 3 months of being divorced, then your will not be applicable. So let's say in your will, you said, I give this house to my wife, so and so. And then you guys get divorced today, and then you die next week. You haven't had a chance, or you haven't been able to change your will. Your spouse will not be able to benefit in terms of that will because of the grace period that the Wills Act provides. But then you only have 3 months. So if you don't change your will within 3 months of divorce, then that will continues to be applicable in it as it stands. So for instance, again, you said your wife can benefit by getting the house, the car, and the business, and then you get divorced and you don't change your will within 3 months, and then on the 4th month after you get divorced, you pass away. Your wife will still get the assets, will still benefit in terms of your will. So you only have 3 months grace period. Anything beyond that, it means that your estate will be administered in terms of your will. So that is why it's important for couples, in as much as it's important to consult a legal practitioner before getting married, it is also important to consult a legal practitioner as soon as a divorce is finalized because of such consequences. So now, the next important question for us to look into is one about disqualification. Who is disqualified from benefiting in a will? So the first person, because this is given rise by the scenarios such as this one. Can I inherit from my father's estate even though I was involved in his death? For instance, can you benefit from someone's estate when you've killed them or when you were involved in their killing? What about an adopted child? Do they have the same rights to benefit from a will as a biological child? What about a child which was born outside marriage? Can that child benefit from a will? So the answer is this. All the people who I mentioned above, or either two of them, can benefit. But if you are involved in the death of the testator, there is a principle in law which we call a bloodied hands principle, which basically provides that one cannot benefit from their own wrongdoing. So you cannot kill a person and then you still benefit from their estate. So if it can be proven that the ex-wife or the ex-husband was involved in killing their spouse, then they are disqualified from benefiting in that particular deceased estate. So a person who signs a will as a witness is disqualified from benefiting in the same will. A person who signs a will as a witness, their spouse is also disqualified from benefiting in the same estate. So, and then the next person is that, so what this means is that if I sign a will as a witness, I'm disqualified from benefiting in that. My wife is also disqualified from benefiting from the will as well. So the other aspect is that even remember, we've mentioned already that there is a commissioner of oaths who has to attest. So even the commissioner of oaths is disqualified from benefiting in the same will. So the last person, or rather another person who is disqualified from benefiting in a will, is the person who drafted the will. I mean, if I'm the testator, then I can't necessarily benefit myself because I'll be gone by the time the will becomes applicable. But similarly, if I request someone to draft the will on my behalf, let's say my lawyer, I request my lawyer to draft the will for me, my lawyer is also disqualified from benefiting in the same will that he drafted. So that's that deals with people who are disqualified from benefiting in a will. Now we move to the last leg of our discussion, which is what about wills in customary law marriages, or how are they different in terms of civil law marriages? So firstly, we need to mention that if a person dies without a will, we call it intestate estate. So their estate will be administered in terms of Intestate Succession Act. But if you die having written a will which is valid, then your estate will be administered in terms of the law of succession according to the will, which is governed by the Wills Act. So we often hear the about situations where someone died, maybe a husband dies without a will, and they were married in terms of customary law, and then the family, it can be the uncles or the parents, they now take charge of the estate, and then they take everything, perhaps not even giving the wife like nothing, so which is wrong, because the law is this: if you die intestate, your estate is going to be administered in terms of Intestate Succession Act, even though you're married in terms of customary law. So for instance, what the Intestate Succession Act says is this: it recognizes a number of beneficiaries or people who can benefit from someone's estate when there was a customary law marriage. So in terms of the act, if someone dies without a will and they leave behind a spouse, then the spouse will inherit everything. If someone dies without a will and they don't leave a spouse but they leave a child, that child, even though the father and the mother were not married, the child will inherit everything, the whole estate of the father. If a person dies and does not have a will and does not leave a spouse or a child, but however leaves parents, then the parents in equal shares will inherit the whole estate. If there is no spouse, there is no children, there is no parents, the siblings in equal shares will inherit the whole estate. So this addresses the misconceptions and the misnorms where we hear that a surviving spouse from a customary law marriage was cut out of the estate. The parents or the family, the uncles, they just came and took charge and took everything, and leaving the wife with nothing, not even with maintenance. That is wrong, and someone who finds themselves in that situation can contact a legal practitioner to lodge a dispute or to challenge those decisions that were made in that particular deceased estate. So it's very important for us to consult with legal practitioners before we make any decisions. Either is to write the will, or to amend your will, or to deal with any estate matter. It is extremely important to consult with a legal practitioner. And Setlaho Attorneys Incorporated offers family law services, which also includes administration of deceased estates. So you can find them at info@setlahoattorneys.co.za. You can also find them on also social media platforms at Setlaho Attorneys Incorporated. So that was our episode on wills. Thank you for watching. please hit the subscribe button and hit the notification button so that as soon as we upload our content, you are the first person who can be able to access it. We thank you for watching our episode. This is Talk Law with Monare. I'm your host, Kwaedi. Thank you for watching, and please remember, the law is for justice, the law is for reparations, and the law is to build. Thank you.